Good afternoon, everyone. Can somebody raise a hand to see if they can hear me and or see me? Thank you, Mr. Finlay. Thank you. That's excellent. Thank you. Good afternoon. It's now 1 o'clock and time to start the pre-inquiry meeting for the public inquiry into the Beauly to Peterhead 400 kilovolt overhead line connection. My name is David Beauly. I'm one of the reporters appointed by Scottish ministers to consider the application. With me today is my colleague Rosie Leven, one of the other reporters appointed. Our colleague David Liddell, who is not here today, has also been appointed to the case as a third reporter. We've been appointed to consider the case, to hold a public inquiry and to report to the Scottish ministers with our recommendation as to whether consent under Section 36 of the Electricity Act and deemed planning permission should be granted. It's the ministers who will decide whether or not to approve the application, having considered our report of the inquiry. This meeting is being recorded and broadcast live to our YouTube channel. By taking part in the meeting, you're consenting to being filmed and to the use and storage of those images and sound recordings and any information contained in them for webcasting and trading purposes, and for the purpose of keeping historical records and making those records available to the public. We haven't planned any formal break in this afternoon's proceedings. We'll see how we get on. We'll review this after about an hour, but if anyone needs a break, just please let us know. We'll be happy to oblige. We expect to be finished, well, we're not really sure how long it's going to take, but certainly by no later than 4 p.m. We'll see how we go on. Important point to make, you probably already know, but the purpose of today's meeting is to discuss the procedural arrangements for the inquiry. It's not to hear evidence, it's not part of the inquiry itself, that will come later. So we won't be hearing any evidence on the merits of the proposal today. We circulated an agenda for the meeting, and a link to that was also sent in the email that provided the joining instructions for this call, so hopefully you've all got the agenda to hand. As we go through the agenda, at various points, we'll identify particular participants that we think would be best placed to provide an answer to a particular question or to comment on a particular point. That doesn't mean they're the only people we want to hear from. So if we haven't asked you specifically to comment on a particular point, please do raise your electronic hand, which you can do by clicking on the raise button at the top of the screen, and we'll then come to you in order, so you get your chance to say on any of the matters that we cover. Participation in the inquiry that will follow is not limited to those of us who've turned up today. It's open to anyone who's opted in to further procedure. So we will hopefully decide today on what that procedure will be and when it will happen, and a note of the inquiry will be sent out providing details of all of that, not just to everyone who's here today, but to everyone who's opted in. So those who haven't come today have certainly not missed the boat. So to kick off, I'm going to ask those who are representing the applicant, the councils, the community councils and the key agencies to introduce themselves. I won't ask everyone who's present on the call to introduce yourself because that will take half the afternoon. As I say, we very much want to hear from you if you want to say something, but probably if you're not one of those sort of larger organisations, it's probably best just to introduce yourself at the time you want to speak. So for the time being, can I ask first, please, who is appearing on behalf of the applicant?
Good afternoon. I'm Paul Reid, KC, and I'm appearing on behalf of the applicant.
Thank you, Mr. Reid. And on behalf of Highland Council?
Good afternoon, sir. It's James Finlay, KC, instructed by Arlene Gibbs from the council. I have with me also Francesca Glendinning, Junior Counsel, and Jack Wiseman from the council is also on the call.
Thank you, Mr. Finlay. From Murray Council?
Afternoon, I'm Aileen Scott, Legal Services Manager at the Council, and I'm accompanied by Andrew Miller, the Senior Planning Officer. Going forward, we will be represented by Ursula Curry at DWF, but we are attending the meeting today.
Thank you. Excellent. Thank you, Ms. Scott. And from Aberdeenshire Council?
Good afternoon, sir. My name is Rob McIntosh, Principal Solicitor, Aberdeenshire Council, and today I'm accompanied by my colleagues from the Planning Services, Elizabeth Tully and Stuart Newlands.
Thank you. And from Nature Scott, please.
Good afternoon, sir. My name is Peter Ferguson. I am a solicitor with Harper McLeod's, and with me virtually today is Jennifer Heatley, who is Nature Scott's Energy Casework Manager.
Thank you, Mr. Ferguson. And from the RSPB, please.
Hi, I'm Esme Cleland. I'm the Head of Planning and Development RSPB Scotland, and I'm also joined by Claire Smith, who's a Senior Conservation Officer with us.
Thank you. I'm expecting we don't have anyone from Historic Environment Scotland because I think they indicated they weren't coming, but can I just check that's correct? Yep, good, okay. So turning to the community councils, is anyone here from Deer Community Council, please?
Yes, Jane Knowles.
Thank you. And Speyside Community Council? No.
Yes, Marion Ross.
Thank you. 5E Rothy Norman and Moncritter Community Council?
Yes, Catherine Vincent.
Thank you. Strathglass Community Council? Strathnairn Community Council? Kirkhill and Bruncheroo Community Council?
Good afternoon, sir. Ian Kelly from Ian Kelly Planning Consultancy Limited, representing that community council. You have a lot of people on the call, sir, so I should just say that other than the matter of ratio and the need case, my clients will be perfectly happy to go along with whatever else is agreed this afternoon. So other than on those 2 points, I don't anticipate saying very much. Thank you, sir.
Thank you, Mr. Kelly. Now, are there any other community councils present that I haven't mentioned? Okay. Anybody else who would like to introduce themselves up front? As I say, it's not by any means mandatory. You can do that as and when you want to speak. But was there anyone else who wanted to say something now? No? We're all content? Excellent. So before I move on to the main parts of the agenda, I just wanted quickly to check on the status of ongoing discussions between the applicant and Highland Council and how that might affect Highland Council's ultimate position on the application. As I understand it, we have effectively a holding objection from the end of last year. I understand the Highland Council may hope to get the matter before its committee on, I think, the 17th of June, at which point it will confirm its finalised position and whether that's changed from its current holding position. I understand there have been various negotiations between the applicant and the Highland Council, and also some discussions between the applicant and Historic Environment Scotland, which may be relevant to the Highland Council's position on heritage matters. So really, I just wanted to check that vague understanding of the Highland Council's position was correct, and that sort of timescale is about right. Can you confirm that, Mr. Finlay?
Yeah, yes, it is. Yes. Apologies for that delayed timescale, but we were working on another overhead line. We changed this overhead line. There are a large number of matters to consider, and the matter will go to the council between now and then. And it may be, even if there is an objection, that it will be on less than 11 grounds, as we're working on some of those grounds. And I should say, of those 11 grounds, we're effectively relying on other bodies to advance 4 or 5 of them.
Thank you, that's helpful. And it was helpful just to hear last night. So we had some advanced warning. That was very helpful. Appreciate that. So we had a bit of a heads up on this matter, and also in terms of the running order for the inquiry itself, which we'll discuss later on. It was useful to have some input on that. Before I move on, there was also a sort of related question, I think, to the applicant. In the light of the discussions, I think, that have been ongoing with the council, the Highland Council, whether it's likely that any changes might be made to the scheme, and if so, I just want to remember to add it to the list, the long list of things I need to talk about under item 3 of the agenda, which is the possible need for additional information. So I don't know if, Mr. Reid, you've got any instructions on that as to whether any changes to the proposal are likely as a consequence of that.
The discussions are ongoing, and as I understand them, are fairly constructive. Nothing beyond that at the moment.
That's fine. That's fine. Yeah, we can say what we know so far. So was there any other procedural matters anyone wanted to raise before we kick off with the agenda properly? No? We're okay. Okay, well, I'll hand over to my colleague who will take you through item 2 of the agenda. Thank you.
Okay, thank you. Good afternoon, everybody. I'd like to give you an outline of the procedures that may be involved in the inquiry. And the application, as you may know, is one of the priority applications for transmission infrastructure. You may hear it being referred to as an ASTI project, and that stands for Projects Within the Government's Programme of Accelerated Strategic Transmission Investment. And back in February 2025, the Scottish Government produced guidance for these priority applications and how they will be processed. So we plan to follow the key stages in that process set out in the guidance, and we will attach a link to that guidance in the note of this meeting for anyone who hasn't seen it. That said, there are no detailed procedures for the conduct of inquiries into these applications under the Electricity Act. However, DPA has produced a code of practice, which has been modelled on the 2013 Planning Appeals Regulations, and we expect to apply the code of practice in this case where it's relevant. So again, if you haven't seen that, the code of practice is available on our website, and we will include a link to it in the note of the meeting. Essentially, the code allows for flexible procedures. So each issue that requires a further procedure will be dealt with by the most appropriate method of examination. That could be an inquiry session, a hearing session, or further written submissions. And on some issues, we may feel that sufficient information has already been submitted and we don't require any further procedures. When we write our report to Scottish Ministers, we will take into account all of the environmental information that's been submitted by the applicants, together with all the consultation responses and all the letters of representation that have already been lodged, as well as the evidence that we gather through the further procedures that we'll be discussing today. Importantly, the type of procedure being followed, or indeed the absence of any further procedure, is not an indication of the importance of a particular issue. So we may have sufficient information as it stands in order to understand the issue and report on it. So at this point, I just wanted to briefly explain the difference between the key elements of the process, particularly for those of you who haven't been involved in anything like this before. So for inquiry sessions, each party will be invited to present evidence from a witness, and this will be subject to cross-examination by those of an opposing view. So usually parties are legally represented and lawyers will do the cross-examination or the questioning of the witnesses, although it's not essential to have a lawyer. We as reporters will also have questions. Inquiry sessions are more formal than hearing sessions, and they're particularly suited to topics where there's a lot of detailed or technical evidence. Written material is required in advance, which states your case, normally what's called a precognition, and an inquiry statement and an inquiry report. So just to explain precognitions a little bit further, each person who's presenting evidence at an inquiry session is required to submit a precognition in advance. And these are detailed written statements summarising the evidence each person will present. They should be concise with a limit of 2,000 words, and they should cross-refer to any relevant documents, but they don't need to include appendices or other technical information or other evidence such as photographs. Those can all be lodged as documents by the date specified, and I'll say more about that later. Moving on from inquiry sessions to hearings. Hearing sessions take the form of a structured discussion between the parties involved, with one or more of the reporters leading that. There'll be no formal leading of evidence or cross-examination. We would prepare an agenda for each of the hearing sessions in advance, and everyone who has advised us that they want to take part can participate in a particular hearing session. There's no need for legal representation, although parties' lawyers can take part in the discussion. Hearings are generally less informal than inquiry sessions, but in advance of a hearing session, all the participants would still be expected to prepare a hearing statement responding to the scope of the hearing. One further option is a community hearing, and this would be a type of hearing focused on understanding the views of local residents and organisations, allowing parties to make brief presentations based on their hearing statements and ideally grouping together those with similar interests. This format allows the reporters to seek points of clarification from those parties if necessary. We would also invite the applicant to attend any such sessions, and if there was a factual point of clarification that was required from the applicant, then that could be made through the reporters. But generally the focus in these sorts of sessions is for us to hear the community's views. So those are the different types of oral session. We will also ask for further written submissions on topics where we need some more clarification or detail, but we don't need further discussions. So you'll see in the agenda and its appendix that we've already set out our initial thinking on how the case should proceed in terms of these oral sessions and in terms of further written submissions. And we will discuss the detail of that soon. And that will obviously take into account some of the suggested changes that we've received from Highland Council. Site visits are also part of our evidence gathering. We've already carried out unaccompanied site visits along the length of the line at the end of last month. And as we further examine the evidence, it may be necessary for us to carry out additional site visits. So that's a summary of the different procedures. Unless there's any particular questions on that at this stage, I will pass you back to Mr. Beauly to take you through item 3. Thank you.
Okay, so before we go on to talk about what would be the best procedure for examining the proposal, we need to establish whether any additional information might be required. Using the term additional information in the sense it's meant in regulations 19 and 20 of the EIA regulations. In other words, where its submission could potentially trigger a requirement for some further form of formal publicity. We need to know that upfront so that it doesn't compromise the inquiry timetable. If anything needs to be advertised or indeed prepared from scratch, we want to know as soon as possible so we don't cause delay to the process. Apologies in advance that this part of the agenda may drag on a bit, particularly for Mr. Reid, I expect, because I'll be asking him lots of questions. I think identifying the need for additional information now or as soon as possible is important to avoid, as I say, the delay in the process. And also following the recent Rayshore Farms judgment, it's important that the scope of the project in EIA terms is correctly identified. Any likely significant effects of that project are either before us as part of the application, or if such effects are not fully identifiable at this stage, then there's a mechanism in place to obtain them subsequently. So I want to deal with the implications of Rayshore Farms first. Obviously, it's a matter of considerable importance in its own right. It's also a potential trigger, as I say, for possibly requiring additional information. We, as reporters, need to turn our mind to the question of what constitutes the project in environmental impact assessment terms. And we need to make sure the ministers have sufficient information to undertake an environmental impact assessment of that project. I appreciate this requires answers to an awful lot of questions, and it, perhaps being very ambitious to think that we might be able to resolve it today, it may well be that we need to seek further written submissions from the parties on what they think the answers are to the various questions I will pose, such as what matters are included or not included in the project, along with the transmission line itself, and then what the implications of those matters being included within the project are, and indeed potentially what implications there might be if certain elements are not part of the project but still might potentially need to be considered in terms of cumulative effects with it. So, as I say, it may well be we don't get very far, or certainly not fully resolved in terms of what we're doing in respect of both the implications of Rayshore and in terms of potential need for additional information. But at least if we make a start on it now, and if we don't get complete clarity on that, we will follow it up very quickly with requests for written submissions when you've had a bit more time to think about your respective positions on it. So as I say, I was going to start initially with asking Mr. Reid what the applicant's position is, but obviously other parties may well have views on that. Mr. Rodwell, your hand is up. Did you want to say something on this particular point now, or something else? Hand's now down. Okay, I'll go on. So, looking at the EIA report from the applicant, the development for which Electricity Act consent and deemed planning permission are sought is detailed in paragraphs 3.3 and 3.4 in Volume 2, Chapter 3. There are two elements, one described as the development and another described as the ancillary development. However, there are also elements that are described as associated works, and these are set out in paragraph 3.5. And the EIA report confirms these associated works are not the subject of the current application, which is fine, but have also not been assessed in detail in the EIA report. And it's those associated works we want to think about and talk about today, and whether, in the light of Rayshore Farms, they perhaps ought to be regarded as part of this project for EIA purposes. We've also set out in the agenda a couple of other items that may need to be considered similarly. We'll come on to those after we've considered the associated works. So for each of those associated works, we think we need to know whether they're part of the project, if so, whether they're likely to introduce significant environmental effects that have not thus far been assessed by the applicant. For each of the associated works, if significant effects are likely, then we need to determine whether such effects are fully identifiable at this time. If they are, we need to determine what additional information would be provided in order to enable us, or ultimately ministers, to assess those likely significant effects. In that regard, we're particularly interested in how that additional information ought best to be publicised, particularly whether we could or should use the exemption that's provided for cases that are going to inquiry under Regulation 26, which avoids the need for the full-blown developer publicity round with press advertisements and the like, on the basis that the inquiry itself will be publicised, so matters that are required for the inquiry will be publicised via an alternative route. So there's that question. As I said, there's several questions. The other question is, if likely significant effects are unable to be fully identified at this time, then we need to consider whether it would be appropriate to consider dealing with those by some sort of multi-stage consent approach. So there's an awful lot of issues to consider for each of the associated works, I'm afraid, and I want to go through each of them in turn. As I say, I don't know whether we'll be able to get clarity on all or any of them at this stage, but at least we'll have a go and see where we get to. So, as I say, I'll turn to Mr. Reid first, but it may be other parties want to have some input into each of those. So the first item, the first bullet point, or I think they were in paragraph 3.5, were the three substations, Fanellan, Greens and the Netherton hub. Obviously they're the subject of separate applications for planning permission. They wouldn't ever be covered by a Section 37 application, that's fine. I think as far as we understand it, Greens and Netherton have actually been approved and Fanellan is currently at appeal. So the first question, as I say, I'll go to Mr. Reid first, is do you consider the three substations to be part of the project in EIA terms?
Well, firstly, sir, thank you for the opportunity to speak first on it. We should say, as a general matter, as was done with Teacup, we would appreciate if there are specific and detailed questions, the opportunity that I can reflect both with the wider team that's sitting in the room with me, and will be aware this is part of a number of projects across those projects, to respond to those in writing. So both you have certainty, and everyone else on this has certainty as to our position in writing, as opposed to any recollection as to what I'm about to say on that. In relation to the exemption procedure, if we get there, it seems to me at least that may be consistent with the thrust of the priority guidance and the expectation as to the speed with which this should be determined. It also seems to me that we may get to a point where we are having to discuss multi-stage consents and the like, but these are all matters on which I think it would be more helpful, sir, if you have the considered position with the benefit of the team I have advising me in writing, as opposed to a more thorough and detailed discussion, not to avoid or elide that discussion today, but so that what you have is helpful on behalf of the applicant. In relation to the 3 substations, you are correct about the stage each of those are in the consenting process, and each obviously have gone through that process separately under the relevant legislation and assessed as they are required in that. I wonder if I've paused there for both sir your benefit, and if you wish to invite others to comment on that before they look at the other 4 items that were listed in paragraph 3.5.
Yeah, thank you, Mr. Reid. I appreciate it. We are putting you very much on the spot. And to be honest, the inclusion of all of these matters in the agenda today was more really to get us thinking about potential implications for the timescale we're hoping to hit, which is quite challenging. As you know, we're looking late August to get to inquiry, and it's really to get us thinking as soon as we can if matters or if there are elements of the project that ought to be added to the project where significant effects are fully identifiable at this stage. We just need to think about the timing implications of how long it would take your client to get that information, and then, as I say, depending on which way we go, the advertising of that may not actually add to the timescale a lot, but maybe the more difficult part will be the extra burden on your client in preparing this additional information. So I appreciate it, and it makes complete sense that you want time to actually consider the sort of legal issues, etc. of it. But so maybe just if I don't know if you're even able to do this at this stage, but if there were matters where you were leaning more towards, well, A, that you accept that part of the project, and B, you were leaning more towards providing the information up front because you think you can, I suppose, so long as you're content that you can do that, with resources available, and you're not saying that actually we need to push things back.
What I can say is that the applicant is fully committed to the timescale and the timetable set out. The resource required to meet that has been allocated, and if that is insufficient, further resource will be allocated rather than further time.
Okay.
So is the applicant's position.
Okay, well, that's good. That's good to know. So we'll leave it at that. Did anyone, just on the substation, did anyone else want to come back on the substations? Mr. Kelly?
My client's position is that the substations are an integral part of the overall project for EIA purposes. I have some considerable sympathy with the position of the parties trying to comment on here. The DPA has evolved in a procedure, what appears to be a fairly standard procedure now for dealing with this, a 2-stage procedure of firstly asking the applicants to make a written submission and then other parties to respond. The position here, I think, is particularly complicated, and I think there would be very significant merit in, once everybody has signed up through the process after you issue the minute of this meeting, for you to issue a procedure notice seeking submissions from the applicants, followed by a response from other parties. It may be 2 weeks, and 2 weeks would be sufficient, but that would be for you to consider, sir. And to maybe preempt a future discussion, we take the same view, my clients take the same view on the need case, that this would be best addressed by you issuing a procedure notice asking for the applicants to set out their view on need, and then other parties to respond again, perhaps again 2 weeks. But I think it would be extremely difficult to resolve this issue this afternoon. So thank you.
Thank you, Mr. Kelly. Anyone else at this stage? Yes, Ms. Finlay.
So just to say that from Highlands Council's position, its current position, although it would wish to see what the applicant has to say about it, is that certainly in respect to the substations, we accept that it would be reasonable to consider they were part of different projects. We reserve our position in respect to other matters. Just so to give notice, one concern that we specifically have in this regard is the removal of the existing overhead lines and the traffic implications of that. But if it looks as though we're going to written submissions, but those are our that's our major concern in terms of the definition of a project.
Okay. Thank you, Mr. Finlay. Ms. Vincent.
Yes, from the perspective of the 5-year Rathie Norman Monwhiter Community Council, I think that we should look at the substations as part of this project, because both of these projects combined are impacting our community, and it's very difficult to pull them apart.
Thank you. Ms. Knowles, please.
I'd like to echo what Ms. Vincent has just said with regard to Deer Community Council as well. The two projects are inextricably linked. Without the green substation, without the overhead line, there is no need for green substation, and vice versa. Green substation has planning permission, yes, but is going to have a massive impact with the overhead line as well, and cumulative other projects in the area.
Thank you, Ms. Knowles. Rick and Anna, sorry, I can't see your second name. It's been chopped off by the screen.
Yeah, no problem, sir. Just to echo that, I mean, I think that they should be considered as one project. The design of one is directly impacting the design of the other, and that is directly driving the environmental impact of each of the other projects, and therefore should be considered as one in its entity.
Thank you, Mr. Land. Mr. Langley.
Mr. Langley?
You're on mute.
I'd like to concur with the immediately preceding commenters. This is an integrated project across the northeast, right up into Inverness. I see it driving down from my forestry business all the way to here. I'm in industry, power industry, so I see it at Peterhead. I see the clearances going there. All of these items are part of the same system, so it's unrealistic to call them different projects. And I think the cumulative effect is what needs to be considered.
Okay. Thank you, sir.
Thank you.
Thank you. Okay, so I think it's probably, I'll come back to Mr. Reid. I suspect it's not going to be any more realistic to get to the bottom of the other matters in paragraph 3.5 in terms of whether they're part of the project, and if so, what implications there might be for procedure, etc. Orally today, unless you correct me, unless you have a strong view or a quick answer to any of the other points, I'm assuming, Mr. Reid, maybe we park this and do, as Mr. Kelly said, what was done in the other line, seek submissions as soon as we possibly can in writing with a fairly tight timescale responses, and then take it from there in terms of what implications that might have for further procedure. You content with that, Mr. Reid?
I'm content with that, sir. I noticed in teacup, I think it was a simultaneous exchange. It's a matter for you, sir, whether you wish to stage it or not, having regard to the overall time we have before the inquiry. I wonder whether if it's simultaneous might be preferable, but that's a matter for your discretion and judgment, and I don't offer a strong view on it. On the others, I agree it's unlikely to reach a landing on them today. What I can say, the second issue is borrow pits and quarries, and as I understand it, the principal contractor has since confirmed that we no new borrow pits or quarries required for the proposed development. So there would be no associated works under that heading. And in relation to temporary construction compounds, I understand the principal contractor currently anticipates one main yard will be required, with some smaller satellite yards, but locations are yet to be established. Beyond that, I do wonder if the expeditious way is to deal with the rest in writing in early course.
Fine. Yeah. I'm rapidly becoming convinced of that. It was worth a try. Up front, we will we'll give some thought as to what would be the best way, because time is pressing on, and it may not actually add any value for parties, kind of, a staged response, being able to address other parties' points. We really just want to know what you all think, and then we need to come to a view and take it from there. So we'll have that discussion. So those are the 3.5, paragraph 3.5 matters. We indicated another couple of elements, which again, I won't expect you to come to a final view on now. Well, actually, before I do that, one query I had on the substations, and it's my ignorance. There was to be originally something called the Coachford or Black Hillock 2 substation, and that was dropped from the scheme quite early on, I think. Question was really, and you may not know this because this wasn't on the agenda either, so I like doing that to put people on the spot. Is there I'm assuming not, but I don't know, is there to be a replacement for that? So are we dealing with 3 substations to cater for the entire route, or is there another one in the pipeline at a later date? If you can't take instructions on that by somebody waving across the room, then don't worry.
If you give me a moment, I'm looking around the table and I'll tell you in a moment whether I want that in writing or whether I'll answer. I'm told we're back at the early stages of even site selection or the like, so it's probably too early a stage. I'll give you a better formed answer in writing.
Yeah, no, it was very. Thank you. It was very cheeky. Thank you for trying. It literally dawned on us yesterday, and we'll remind you of that in the written request for further submissions. So those are the 3.5 matters. There were 2 other things that we were identified maybe as requiring thought in terms of the Rayshaw judgment. One was the proposed off-site compensatory tree planting, and again, I won't expect you to answer us, but we'll mention that in the request for written submissions. And the other was kind of a query. There was reference, I think we referred to a yard at Croy, but then looking in the chapter 13, the transport chapter of the EIA report, it talks about 5 yards. So I didn't know whether those yards were the construction compounds or whether they were something else. Again, you may not know that, although what you just said about having a main yard and satellite yards, I didn't know whether this was something else on top of the construction compounds or it was the same thing.
No, it's the same thing. It was an indicative yard location, but the precise locations are still to be confirmed. And as I said, right, we understand the principal contractor currently anticipates 1 main yard, right, for the project.
Okay. Again, we'll mention that in our request for further submission, just so you can confirm that to us and what implications that has in terms of Rayshaw. That was all I wanted to say about Rayshaw, unless anyone else has anything to say. Nope.
I
think those are legacy hands, I think. Ms. Vincent and Ms. Rodwell, could you put your hands down? Unless you want to say something again. I think you've just left them up. Brilliant, thank you. So, moving away from Rayshaw, a more typical issue that might require additional information is in terms of the cumulative effects assessment in the environmental impact assessment, particularly from a landscape visual point of view. Quite often developments have popped up since the original LVIA was carried out, and I don't know, so I'm asking the question, are parties aware of any other big infrastructure projects or things that might require cumulative assessment that would require an update to for example, the LVIA? Mr. Reid, are you aware of anything that might need updating?
I think what I should notice at this stage, sir, is our consultants have identified in conducting a review that the Clashgower wind farm has been partially omitted in the EAIR. It's our preliminary view that this can be appropriately dealt with by way of a short technical note covering any necessary updates to the EIA. We expect to be able to confirm our position in relation to that early next week, including a timescale for a technical note. That issue was identified earlier this week. Right. I think I should draw attention to that. Otherwise, there's nothing in particular I wish to draw to your attention at this stage.
Cool. Okay, thanks. And that technical note doesn't sound like it would be additional information, or does it? It's not how you describe it. It doesn't sound like it's going to be lots of new drawings and things. And
I obviously don't know till I see it, but I don't anticipate that it's going to be an additional information category. That'll ultimately be a matter, sir, you can take a view on when we produce it if your view differs from ours.
Excellent, thank you. Mr. Rodwell, you have your hand.
It's actually Mr. Thornton Kemsley using Mr. Rodwell's computer, sir. I think with regard to the ratio judgment, I think you do need additional questions with regard to whether or not the applicant has adopted the correct methodology for determining a safe and lawful clearance for the new line crossing productive agricultural land. Our position on behalf of our clients affected by the route is that it has not. Moreover, it is our position that the EIAR has not properly addressed the operational effects of the proposed line on agriculture, notwithstanding the fact that agriculture is the dominant land use upon a significant proportion of the route. And therefore, sir, you need to consider whether the application has been assessed on a legally and methodologically sufficient basis. In short, unless a safe clearance is derived by reference to foreseeable agricultural operations along the route, the proposed design has not been properly justified.
Okay, well, we are going to come back to agricultural implications, safety and other implications for agriculture later on. So I will.
Well, whichever schedule, whichever bullet point you want to put it under, that would be a point that we would wish to submit on.
Thank you. It's on the agenda. We'll make sure we do cover that. Mr. and Mrs. Lowndes.
Just one other project that we're aware of is that the applicant's deemed to be has had consultation on and is looking to submit an application for the Black Bridge replacement, which is associated to allow them to achieve the Fanellan substation, but presumably is also to allow them to access the terminal and the end towers of the overhead line at the Fanellan end. I don't know if that was at the time they did the EIA, etc., wasn't on the planning application. They were intending to try and come via a different access route.
Mm-hmm.
Okay. Yeah. Was that the? Yeah. Thank you. Yes, we had a note, in fact, of that point, Mr. Lowndes. Was this tied up with the garden and design landscape point? So yeah, as I understand it, again, Mr. Reid, you may not know the answer to this off the top of your head, but as we understand it, there were, as part of the negotiations with Historic Environment Scotland about minimising effects on the Beaufort Castle garden design landscape, some changes were proposed to, I think it was to the access, construction access route, which would have gone through the garden design landscape, going to the Fanellan substation. And I think that's been changed around, and whether that could potentially have some different implications, perhaps traffic implications by rerouting the traffic somewhere else. So I think we'll just mention it again in the note, just as another matter that you maybe need to think about as to whether significant effects from that change are likely, and if so, how you would tell us about them, or not, if you think they're not likely to be significant. I don't know if you have anything to say at the moment, Mr. Reid, on that.
I'm not going to say anything at the moment. I'm looking at the sea of face. I don't think I can give you a short and immediate answer to it. But what I can say, given the number of people listening, is listen to carefully, and it is very helpful to hear the points that are being raised and that people wish us to address, and hopefully understand why I want to do that thoroughly and fully and in writing.
Good, thank you. Mr. Finlay.
So it's just a question, or a point of the exchanges. Mr. Reid has suggested simultaneous exchange. I don't have a particular issue with that, but there may be factual matters such as the borrow pits point that Mr. Reid has just mentioned, to which he's referred, to which it would be useful to parties to be able to respond. And indeed, the applicant may wish to respond to some of the points other parties have made. So whilst I appreciate the need to get on with it. Perhaps there could be a chance for a response, say within 7 days of any simultaneous exchange. And a plea to the applicant that if they know any other factual considerations, such as the lack of requirement for borrow pits, which doesn't come as a surprise to us, it would be useful to know that as soon as possible. But I don't think I'm not asking for any specific direction to that end.
No, when just talking about the Fanellan point got me thinking of there could be unforeseen consequences of making what appears on its face to be a good change. For example, getting rid of on-site borrow pits might require, or presumably does require, importation from off-site, which could have other consequences, perhaps of a different nature. So, that being the case, other parties might want to point those out to us. So again, we'll talk about this, but maybe a short response to the initial response might actually not be a bad thing, just so we're not only knowing how the project has maybe changed or what constitutes the project, but possibly if other parties want to tell us if there were to be any unforeseen consequences as a consequence of those tweaks to the project, whether those require also to be assessed. So yeah, we'll talk about it, but I hear what you say. We'll give that some thought. Okay, so have a look at where we are. So we had raised on the agenda a query, I think, that came from Highland Council Roads team about, and I think this may have been a point, I think, Mr. Finlay, you mentioned about the removal of the 132 kV Beauly to Knocknagale overhead line and various temporary and permanent diversions to power lines and some tree felling works. I think all of this is included within the ancillary works description in paragraph 3.4 of the IA report. So it's not one of those associated matters that definitely wasn't assessed. But I understand from the Highland Council's roads team's response, and I think, as I say, from what you said, Mr. Finlay, that Highland Council's position is they haven't been fully or properly assessed. Is that right, Mr. Finlay?
Yes, that's our position. Our position is set out in that roads response, which I think was attached to our objection. But yes.
Okay. I don't need you to come back, Mr. Reid, unless you particularly want to. Again, this will be added to the long list of further written submissions, and you'll get the chance to say what you have to say on that point as well.
Thank you.
The other issue that we had a query on, it was a query really, was the approach taken to residential visual impact assessment. And I think, although this was scoped out of the EIA, and I think the applicant's view at the time was effects on residential receptors are anticipated to be captured sufficiently and holistically within the LVIA to identify significant adverse effects. So without doing a separate standalone RVAA, I think we're right in saying that that's a different approach to what was taken in the other two main ASTI overhead line projects. We need to be confident that we've got sufficient information to make an assessment of likely significant effects on residential visual amenity, whether any individual property might be affected to such an extent that it reaches the threshold. So, I think it's probably easiest if we put our thoughts in writing as to whether we think we have sufficient information, unless you have anything to tell me at this stage, Mr. Reid, as to why you think we do and why the approach on this line seems to be different from your client's approach to the other two ASTI lines.
No, sir, you've identified the passage in chapter 7 of the EAIR, I think it's at page 752, where our position is it's effectively captured in the assessment. If there are more specific concerns, then I would appreciate the detail of those to reflect on them and respond as we consider appropriate on that. But we are grateful for the insight to the concern that you may have.
I think our issue is likely to be, or may well be, just how easy it is for us to extract from the information you've given us a sort of property by property assessment, given that it may be, and it seemed to be the assumption that properties within a particular group would be affected to a similar degree. We think that's the approach. We just need to be content that we're confident that that is actually a reasonable approach, and that there aren't, in fact, some properties that would be far worse affected by virtue of looking straight at something. Or so we'll set out what our queries are in this ever-growing note, and we'll let you know what we're thinking or what our concerns might be, because we need to make sure, from a landscape visual perspective, the RVAA element may well be one of the more important aspects. So we need to make sure we've actually got sufficient information to be able to recommend to ministers, notwithstanding that this was screened out or scoped out at the scoping stage. Ms. Masson, I'll come back to you, Mr. Reid.
Yeah,
Ms. Masson.
sorry. Yeah, I just wanted to make the point. I made several representation during the course of the development around that particular aspect, and largely it has been, I would say, ignored completely. I did include this in my objection as well, in consideration of the fact of cumulative effects of other existing lines and the new line, and being triangulated between them. So I think this is an important point, even though it was not considered.
Thank you. Okay. Well, as I say, we're going to look into that as to whether we think we've got enough information. Certainly, there is information before us, and it is an important issue that we will be looking at. Whether we ask for more information or not won't degrade its status if we don't ask for more information. It's still going to be a very important issue, but it's just whether we're confident we've got enough from the information that we have to be able to adequately and easily, to be honest, assess the effects on each individual property. So it's very much a live issue. Thank you for that. Mr. Langley.
Thank you. Similarly, this is something that affects us. I've been through all the documentation and I understand how they're mapping it, but I did query SSEN about why our particular location was omitted from all of the views, and they did offer to show us a visual several times of what the impact would be on us. However, that was not forthcoming until the planning application went in, at which point they refused to give it to us because it would affect the planning application. At the same time as saying it had no material impact. Now, you can't have it both ways. Either it affects it and your planning application is not complete, or it doesn't and you're being difficult. Either way, it's not a good look, and this is one of the reasons I got involved in the first place. It is, a year of trying to get an answer and getting no response. So similarly, what's going on actually?
Mr. Lammy. Mr. Reid, did you want to come back?
It was nothing more than agreeing and noting your observations, sir.
Okay, thank you.
Thank you.
Right, so ornithology, as we know, there's a formal objection from Nature Scott, primarily, or I think the objection itself is based on the effects on the Darnaway Leithen Forest SPA and the Capercaillie there. And there's also some other questions about disturbance from construction and things like that. I suppose two questions, really, whether the applicant is proposing at this stage any additional mitigation or any changes to the scheme, and whether that might constitute additional information. If so, we need to make sure that's in hand. You may not know that at this stage, but that's something we need to think about. And also there's the question about the derogation and maybe some sort of shadow derogation information that, if, regardless of which way we recommend to ministers, they need to have the option to go either way on this. So if it were concluded that the proposal would harm the integrity of the SPA, and notwithstanding that they were still minded to approve it, they would want to be advised on what grounds there would be. So I suppose two questions: are you proposing any tweaks to the scheme or any additional mitigation, and might that constitute additional information? And B, are you proposing, which I think you might be, or at least considering, offering some derogation type material, and would that constitute additional information or something else?
We are continuing to liaise with Nature Scott and RSPB to understand the areas of divergence and the extent to which common ground can be reached. That has been a productive process, and we're grateful to them for their engagement. We remain open to the possibility of the submission of a shadow derogation case, depending on where we get to with those discussions. If that proves to be necessary, it is our intention to submit that by the end of May, is where we would be with that. I hope that helps for where we are at the moment.
It does, yeah, thank you. Ms. Scott.
Thank you. It was just similar to the point that was raised by Highland Council in their letter to you yesterday. Murray wouldn't intend to become significantly involved in any discussion on ornithology, although capercaillie were mentioned in our objection. We would leave that to be discussed by the experts, Nature Scott and RSPB.
Thank you. Right, Ms. Cameron, please. You're on mute.
Hello.
Hello.
As a resident in Murray, it's to do with birds and other wildlife. The SSEN transmission as part of this project have already carried out research work in an area during breeding season that has wildcats, pine martens, badgers, numerous birds, and they have carried out boring hole work for these pylons and during breeding season of all times. They've been in there for January and to mid-May, mid-March, end of March, and no thought. We contacted Nature Scott, who said they had a survey. No survey can be provided to us. And I stay just at the back of the woods where they're planning, and we have nightly footage of Scottish wildcats, pine martens, that during the works all disappeared, but have slowly started coming back. But I don't think they have took into consideration the wildlife at all.
Okay. Thank you, Ms. Cameron. RSPB, Ms. Cullen, please.
Thanks. Yeah, it was just to note that if there is more information that's submitted in terms of ornithology, whether that's mitigation or information on a shadow derogation, just to ensure that we've got adequate time, or all parties have adequate time to kind of respond to that and consider that. But yeah, appreciate that the applicant's been in contact recently with us to carry on those discussions.
Good. Okay, thanks. Yeah, I'm sure, Mr. Reid, you'll be including RSPB, will you, in your discussions with Nature Scott?
Yes.
Excellent. Thank you. Mr. Ferguson, as your hand's not up, I'm assuming you don't have anything to say at this point on capercaillie.
Other than should additional information be submitted or compensation proposals be submitted as part of a shadow derogation case, then Nature Scots will of course consider and advise on that.
Excellent. Thank you. Okay, so we're almost through item 3. Cultural heritage, I think, was the next. Yes, it was next issue. We're aware that the applicant's been talking to Historic Environment Scotland, and in respect of the objection they had previously on the Beaufort Castle Garden and Design Landscape, that objection has now been withdrawn. And I think there's also contentment on their side in respect of the Mains of Daviot, subject to a condition. So we've had some further information that's come in respect of that those exchanges, the product of those exchanges. Mr. Kelly, I know you've queried whether, or your opinion is that that constitutes additional information that requires to be publicised formally. Could you just explain your reasons for that, please?
Just sir, from reading through the detail in the technical note and looking also at whether there might be associated implications in terms of other environmental effects, it was a matter that I just wanted to raise with you. I'm not setting it out as a definitive position that it must be advertised, but I certainly wished you to consider whether it should be advertised, sir. So really, I'm content to leave it with you.
Okay. Well, I'd say our initial response is that the changes themselves, or the information that has introduced the changes, doesn't constitute additional information. However, as we said earlier, there could be other knock-on consequences of the changes made to protect the GDL, which might have other effects, which might in themselves require additional information. So again, this note will explain what we're thinking in that regard and ask the parties to submit to us what they think. Thank you for raising that, Mr. Kelly. And the final point I had on my list was in relation to Highland Council's transport concerns, but I think we've dealt with that effectively, so I don't think I need to go back on that. So I think we've made some progress on that, at least insofar as we've agreed we can't resolve it today, which is no surprise. Does anyone have any other matters they wanted to raise in terms of additional information and or the implications of racial? Start with Mr. Davidson, please.
Yeah, just on this, what's over the 400 kV pylon. On the entry to Peterhead, this was all publicised and I've attended every meeting regarding this. Over the last few months since November, there's been contact by SSE to myself to say that they are rerouting the pylon effectively directly over my property. But this is, I've asked this question multiple times where I would have actually raised objections or whatever else. But for this has now been not even proposed yet. It's not even official, but that's now been since November. They've now turned around and said, right, okay, we are altering this. Answers being, because what we looked at before, it doesn't work. It's not feasible. So it's just to highlight that point.
Okay, yeah, no, that's interesting. Mr. Reid, do you know anything about any proposed changes, tweaks to the line of the line? That's the word.
Not as part of this project, but obviously what's been said has been heard, and no doubt someone around this table will be looking into it.
Okay, I mean, there's obviously potential limits of deviation, etc. I wonder if that is something that might be. It would be good to know, especially for the person affected, as to what the status of that, talked about.
Some doubt whether it is within this project, but it will be
looked. Okay.
The matter will be looked into.
Thank you. Okay. Mr. and Mrs. Lound, please.
It was just to ask us whether obviously the Fanellan substation was rejected and is currently under appeal, albeit it's not as far forward in the process as this is. How does that feed into this review process? Because potentially the decision on that review will directly impact the design, location, etc. of this assessment that you have been asked to report on. So just how does that all integrate in to it, and does one need to go before the other?
Yeah, it's a good question. It's been dealt with by, or will be dealt with by, colleagues of ours as an entirely separate project. But there may be, depending on what the outcome of our consideration of the Rayshore Farms case, it may be that all of the substations and the line connecting them up together, if they were regarded as one project, then very much the environmental effects of that would need to be considered upfront at the stage of, or at the earliest possible stage anyway. If they were considered to be separate projects, then they would be considered separately, albeit an assumption I think would need to be made that the two different projects would coexist. So there need to be a consideration of what would happen, what would be the cumulative effect of having a line and having a substation in all the sort of environmental effects of that. And there's also, of course, the consideration of you don't need one if you don't need the other, or if you can't have the other, you don't need one. So they're all tied up together effectively. But we won't be involved directly in the deciding or recommending to ministers whether the substation should or should not be approved. But we will be having regard in some form to that substation and the other substations in our assessment of this. So if you have concerns about the potential cumulative effect of the two, then those are very much relevant matters for us to consider, even though we're not actually dealing with the substation, if that makes sense.
Why we're attending today. So.
Yeah, that's what we're worried about.
Good. Ms. Allen, sorry, I think I missed you out.
That's okay, thank you. I'm resident in Aberdeenshire. I have to date had 3 different contractors on our property looking at our water sources, and I'm curious as to why water isn't something that's being considered here, because the potential of the depth of the bases could impact on people's water supplies and drainage.
Yeah, well, that certainly is an important consideration for us and for ministers. I think at this stage, our view is we have sufficient information on that. They have looked into that in the environmental impact assessment report. And
not to us, they haven't. We have had no response, despite numerous requests to SSEN, as to the outcome of those findings.
Right. Have you looked?
Our view from our own information that it could significantly impact on at least 10 properties' water supplies.
It would be worth looking at if you haven't done already, the environmental impact assessment report, the IAR, as they call it. There will be buried in there a chapter dealing with water issues, and there'll be some technical appendices also, which will explain the outcome of whatever investigations they've been doing on the site. Obviously, you need to make sure whether you're, content with those. If we think we need further information, because we have some queries, having looked at that information and looked at what people have told us and their concerns about water, then we would be writing out to parties and saying, you don't understand this, or there's a radical disagreement over this particular site or property, etc., in terms of the water. Convince us as to why your position is correct and not the opposing position. But if you haven't looked already, the first point I think would be look at the environmental impact assessment report, which is on our website, DPEA website. I find the easiest way to search for anything in the EIAR, if you can use a keyword search of volume, because then you'll pick up all the various volumes and you can go down through all the chapters and find out which.
Yeah.
Chapter 10.
Sorry for interrupting, sorry.
No.
I have looked at that, but given that I'm a bit like the other person who's spoken, there are indications that there might be movement of sites of where things are. So therefore that has come post any impact assessment that was done initially. So therefore actually what's there is potentially incorrect. And without having technical people that can actually give you the answers from our perspective, I find that really quite worrying.
Well, the scheme that is described and assessed in that report should be the scheme for which consent and permission is sought. They shouldn't have changed it since then.
If they move one pylon base, that's then going somewhere different.
Yeah,
Therefore potentially impacting differently.
Indeed, it could, but I don't think that is, and I think I don't think any changes have been made to the scheme. Mr. Reid will correct me if I'm wrong, but I think the scheme is the scheme. So the EIA report details the scheme and it assesses that scheme. It doesn't assess any changes that might have been talked about, etc. But it's certainly an important issue, one of many important issues that we need to look into. As I say, if we think we need further information because we're unsure about anything, we will be writing to anyone who we think is able to provide us with information we need to see what they have to say. Ms. Masson, next, please.
Yes, I have actually looked at the EIA with regards to this topic and have noted that our property has not been considered in it. In addition to this, I have also noted inaccuracies in the information provided, whereby they're showing public water supplies where there is only private in the area. So it is fairly inaccurate in some senses.
Okay, we need to make sure we look at this very carefully.
And these points have been raised with SSEN.
Thank you.
With no response.
Thank you. Mr. Langley.
It was just to reiterate the point made by the previous two speakers that the EIA is not comprehensive. Through selection of maps and stepping them, for example, our area is gapped out through picking different receptor points. Some are discounted, some are included. I've asked several times, I've been referred back to the documents that I've queried as containing the information that I was querying because it wasn't contained in the information. So being referred to the EI report isn't necessarily very helpful if it doesn't cover it in the first place.
No, okay.
Thank you.
I take your point.
Could I ask a question just at this point, Mr. Reid, just about those detailed maps? Am I right in thinking that the detailed maps that show the actual line with the limit of deviation, those very detailed maps just are attached to the position statement that we got in February rather than contained within the EIA themselves? Or have I missed them somewhere?
I think that I understand they're in the EIA, but that could be checked, and the particular reference or detail can be provided. But my understanding is they're in the EIA.
Okay, if somebody could check that this afternoon, that'd be great, and we could just have clarity before the end of the meeting, if possible. Thank you.
Yeah.
Ms. Cave, please. You're on mute, I think. You're still on mute. Still not hearing you. No. Okay. Okay, that was all I had on item 3. Apologies for the long length of time it took to go through it. I think it's helpful. Hand over to my colleague to deal with item 4 on the agenda.
Okay. Thank you. So, yeah, I'm going to turn to item 4, and I should say again at this stage that all the written material that already has been submitted.
Okay, that was all I had on item 3. Apologies for the long length of time it took to go through it. I think it's helpful. Hand over to my colleague to deal with item 4 on the agenda. Ms. Cave, I think we might have a bit of a lag.
Turn to item 4, and I should say again at this stage that all the written material that already has been submitted.
That was all I had on.
Let's just pause for a second.
Apologies for the long length of time it took to go through it. I think it's helpful. Hand over to my colleague to deal with item 4 on the agenda. Ms. Cave, I think we might have a
turn to item 4, and I should say again at this stage that all the written material that already has been submitted.
Apologies, Ms. Cave.
Let's just pause for a second.
Right, can you hear me, Ms. Cave? Can you say something? No, I think we're still having problems.
I'm not sure whether everybody can hear me, but I suggest we take a break for 5 minutes.
Yes, I can. I can hear you fine.
Oh, okay.
Sorry about that. It just rather demonstrates how poor our communications are here. One thing I've noticed on an upcoming Yes, I can. I can hear you fine. Sorry about that. It just rather demonstrates how poor our communications are here.
Miss Cave, I wonder if you could switch off and come back in again, because we're going round in a loop.
Yes, one of the upcoming meetings, if I can catch up with this,
right? Okay.
is about
I wonder if you could switch off and come back in again, because we're going round in a loop.
Yes.
Should we have a break now?
Yeah, I think we'll try.
Hello?
Hi, I think Miss Cave, I know that you might be there and you might be able to hear me now, but I think it might be useful we just have a break for 5 minutes. If you could come out of the meeting and join back in again, and then hopefully by the time you join again, it'll all have caught up. So if that's okay with everybody, I'm hoping that you can hear us, Miss Cave.
Hello?
I think we'll try. Hello? So we'll have a break just now. We'll come back in at 20 past. But I think it might be useful we just have a break for 5 minutes. If you could come out of the meeting and join back in again, and then hopefully by the time you join again, it will all have caught up.
So
Okay.
if that's okay with everybody, I'm hoping that you can hear us in this case.
Okay, assuming anyone can hear us, we'll come back at 2:20.
Yeah.
Thank you.
people are back and that they can hear us okay. Could I get some thumbs up from some people?
Yeah.
Thank you, Mr. Reid. Miss Cave, are you back on the call now and can you hear us?
Not
yet. One thing I would say is that potentially the issues with maybe if there's more than one person sitting in the room together, that there should only be one microphone on, one audio source. So if you are sitting with other people, please make sure that microphones are off on other laptops. And if you're not speaking, make sure that you have switched your own microphone back onto mute. So I'll just try once more to see whether Miss Cave is with us. Can you hear us? You are lighting up, but you're not. We can't hear you. Right, I think what I'll do is I'll try and move on. Miss Cave, I'm not sure if you can hear us, but if you could put yourself back on mute, and then I will make sure that you get another opportunity to speak at some point during this item. I hope that's okay so that we can move forward and perhaps your connection will improve over the next few minutes. So I just want to move on to item 4. That's where I was getting to. And I was just saying that all the written material that's already been submitted will be taken into account, including all the representations, consultation responses. Could you just go on to mute at the moment, please? Whoever's speaking. And so we've had a discussion about a number of potential matters for additional information. So obviously those matters will be subject to further requests for submissions. But our initial assessment of the issues that people are back and that they can hear us okay. Could I get some resolved to sorry. Can I just check that everybody has got... Miss Cave, are you back on the call now and can you hear us?
Yes, I can hear you fine, thank you. Hello?
I would say is that potentially the issues with maybe if there's more than one person sitting in the room together, that there should only be one microphone on, one audio source. So if you are sitting with other people, please make sure that microphones are off on other laptops. And if you're not speaking, make sure that you have switched your own microphone back onto mute. So I'll just try once more to see whether Cave is with us.
Hello?
Can you hear us? Hi.
Yes, I can hear you.
I think we're going round in a circle. Just hold on, I'll go and see if we can get some assistance.
It's not going to work, is it?
Lighting up. You're not. Can't hear you.
We can hear Miss Cave.
Right, I think what I'll do is I'll try and move on. Miss Cave, I'm not sure if you can hear us, but if you could put yourself back on mute, and then I will make sure that you get another opportunity to speak at some point during this item. I hope that's okay so that we can move forward and perhaps your connection will improve over the next few minutes. So I just want to move on to item. Including all the representations, consultation responses. Could you just go on to mute at the moment, please? You're speaking. Right, my colleagues in the IT team are suggesting that perhaps Ms. Cave or others are perhaps if you're watching the live stream on a separate device at the same time, that might be causing this loop that we're getting into. So if people could switch off other live streams if they're on the Teams call, that might help. And also I think we'll try and mute Miss Cave at the moment and see if that helps. And as I say, we'll try and come back to that. So I'm going to just hold my breath for a second to see if these words that I'm saying are going to come back to me again in a second before we progress.
I believe the loop is only because Miss Cave has got such a long time delay. Her laptop is then playing your volume 10 seconds later. It doesn't know how to suppress that, so it then plays it back to you. So as long as she's on mute, then you won't hear yourself come back.
Well, the other option is that Miss Cave comes out of the call and continues to watch the meeting on YouTube, and if there are any points that she wishes to make to us after the meeting, she could do that to us in an email. That might be better so that we can progress with the agenda. So I hope that she can hear, at least through the Teams meeting or through the YouTube channel, and accept that we'll try and move on at this point. I'm just going to give it a second to see whether that changes things. Right, I'm going to give it a go and try and progress for the third time. So the appendix to the agenda, which you will have seen, has set out our initial assessment of the main issues that we think need to be addressed by further procedures. Now, as we've mentioned already, Highland Council has raised some timetabling issues last night, and we have looked at some reorganisation of the days. And having considered various options on dates and logistics, we think it would be possible to reorganise things within the overall 2-week window. But that will be subject to hearing your views today, and I'll discuss our proposed changes on that as we discuss each session as we go through them. So let's go through them now, starting with a number of community hearings which we would like to hold in person. This provides an opportunity for interested individuals and community groups to set out their views directly to us without the need for technical evidence or cross-examination. So we would welcome views on these locations, but our current thinking is that we would have 3 community hearings, one in the Aberdeenshire area, possibly Turriff or Peterhead. And the agenda has this penciled in for the 17th of August, but we think this could move to the second week, to the Tuesday of the second week, which would be Tuesday the 25th. I will go over all these dates at the end again. We would also look to have one in the Murray area, possibly Elgin or Keith, and the agenda has that penciled in for the 18th of August, but again, we look at potentially moving that to the Monday of the second week, so that would be Monday the 24th. And also one in the Highland area, possibly in Beauly or in Inverness, penciled in the agenda for the 19th of August, but perhaps moving that to the following day, the Thursday the 20th. So ideally we'd like these sessions to be webcast, and that would allow others who are not actively participating to observe the sessions, subject to all the IT working, hopefully. And final decisions on that will be made on the basis of our staffing and webcasting resources, but certainly venues that have got good broadband connectivity would be preferable to give us that option. And there's other things that we would find useful from a practical point of view, such as multiple sockets, opening windows, which are apparently useful if we have to use our Starlink connection, and rooms with plenty of space, because we don't know yet how many people will wish to attend. So we'd be grateful if perhaps the councils could suggest a suitable venue in their area, ideally today or by early next week via email if possible, and then DPA colleagues can proceed to organise the booking and management from there. And as well as the venues, we'd certainly welcome views on the best timings for those sessions. We have some flexibility on the exact timings, but most likely it would be afternoon or evening on those days, perhaps starting at 5:30, but we'll take views. And we anticipate one session in each location on the suggested day, lasting up to 3 hours. So for those participating in the community hearings, we would request a short hearing statement in advance of up to 650 words, and for any other visual material to also be provided in advance. So this is not about providing new evidence, but about getting across the key issues that the person in question wishes to raise. So providing that hearing statement gives us an indication of what you'll want to highlight without the need to set out your statement word for word at that point. At the hearing itself, we anticipate participants having around 5 to 10 minutes each to make their points, but exactly how long will depend on how much interest there is, and therefore how we can schedule everyone in. So as I mentioned before, there are benefits if parties group together if you have similar interests. So it could be possible for one representative to have longer to speak if they're making points on behalf of a number of people. So that is the sort of outline of what we're proposing on the community hearing. So I'll stop at this point just to ask for any views at this point. So perhaps the councils, do you have any views first of all?
No, but I'm not in a position, I don't think, today to tell you of a venue. If I'm receive that information during the course of the call, I'll let you know. But otherwise, we'll advise you as soon as we are aware of any in writing.
Okay, but are you happy in principle with such an event on, I think we were talking about the Thursday the 20th for the Inverness area?
Yes.
Okay, that's helpful. Murray Council? Eileen?
Hi. Yeah, we're happy with the proposed date, and we would suggest perhaps a more suitable location in Elgin, and we would suggest perhaps Murray College or the Lake Murray Hotel.
Okay. That's very helpful, thank you. Yeah, we weren't sure whether Elgin would be the best location. That's helpful. Is Aberdeenshire here? Is there any comments that you'd like to make on that? Mr. McIntosh?
Yes, good afternoon. We wouldn't be able to confirm a venue today, and actually might even find it challenging early next week, given the parameters, and also because it overlaps into the school holidays. A lot of our community venues are focused in schools, but we'll do our best to endeavour to get an early response back as quickly as we can next week.
Okay, so the Aberdeenshire event is proposed at the moment for the 25th of August. Is that still within the school holidays, or do the schools go back the week before?
Schools are back the week before. They're back that week. But that date's fine for the Aberdeenshire team. But we'll work hard. We'll liaise with the various area managers to try and find a suitable venue.
Okay, that's helpful. And does anybody else want to comment? Any of the community councils or the applicant? Anyone else? No? Okay, that's helpful. So, Mr. Kelly? No? Would you like to?
I was going to have to shout. It's going to have to shout there. I think the only community council in the Highland Council area that has objected and is taking part is as my clients, and therefore the preference would be for the venue to be in Beauly. And again, we'll liaise with people to suggest a venue that meets the requirements for your IT team. But certainly the preference would be Beauly, and what we'll find, the date will be fine, and we'll also provide statements in advance. So yes, we'll cooperate with that.
That's great. So maybe if Highland Council could consider that, whether they were content also with Beauly, and then we could hopefully agree that location at least. Okay. Anybody else? No. Okay, so moving on to the other topics. So landscape and visual, we anticipate an in-person inquiry session for landscape and visual issues. This is intended to be a more technical session focused on the main areas of disagreement in evidence between the main parties, particularly at this point Highland Council and also Murray Council as objecting councils. And that would involve cross-examination of the witnesses for each party. As we're suggesting ample time, up to 3 hours for the community hearings, we're not anticipating a large number of individuals participating in these sessions, but certainly if community interests did want to participate in an inquiry session, it would probably be more effective to group together, to nominate one person to act as a witness on your behalf. Obviously, you don't need to decide that today, but we would encourage interested parties to have a think about the best way to get your points across, bearing in mind that there's no point in us hearing the same evidence across 2 different sessions. So individuals may find that the community hearings give you a bit more flexibility in setting out your concerns without the need for cross-examination. In terms of timings, we had originally penciled in 2 days for the start of week 2, but following Highland Council's comments last night and subject to views today, we are looking at moving that to the Tuesday and Wednesday of the first week. So that would be the 18th and 19th of August. And whether we stay in one location on both days or we move to different locations will really depend on who wants to opt into that session, who wants to participate. And there's also the option to hold the inquiry virtually if there's a wide spread of parties. So we would certainly welcome people's thoughts on that today. So turning to you then, I see Ms Scott, would you like to comment first?
It's just to confirm, as possibly is the case for some others, we are having some difficulty securing a landscape witness, so we don't yet have a confirmed party to represent us. So I can't say for definite if the dates are appropriate or suitable for us. We'll try and accommodate it, but I think balancing that and getting a witness and trying to just meet all the additional representations and things, it's quite challenging.
Okay, I appreciate that. It is very challenging. Have you got a timescale for when you feel you will know more on that?
Yeah, we're working on it for this and another inquiry. Additional representations and things, it's quite challenging.
I appreciate that. It is very challenging. Have you got a timescale for? Okay, that's stopped.
I'm frightened to speak.
Are you still there, Ms Scott? Yeah, carry on.
Yes,
try again.
I am. Yeah, we're working on it for this and another inquiry, so working on it just now, and we will confirm as soon as possible.
Okay, right. We'll be back in touch. That's helpful. Highland Council, Mr. Finlay, do you want to comment?
Thank you very much for taking into account our letter. I think both those days are suitable. I think if it's going to be an inquiry, we prefer in person. And I'll leave it to you to judge whether it's sensible, which is happening in the other overhead line inquiry, to have one day on Murray and one day on Highland, or whether to have both. But if it's one day on Murray and one day on Highland, then it may be suitable to split between Inverness and Keith. Otherwise, it might be sensible to be in the same location, whichever that location is.
Yeah, okay, that's fine. We'll have to take that decision once we see who's opting in on that. Okay, is there anybody else who wants to comment? Could I hear from the applicant, Mr. Reid?
Thank you, ma'am. The 18th and the 19th of August are suitable for our witness and representatives. Matters as to whether they're split location and the like are entirely matter for you. I always have a preference for doing substantive witness work in person, and I think that would be preferable. I have no strong view as to whether it's an inquiry or a hearing. That's again a matter for your discretion. It seemed to me it could be capable of being done with a hearing, but it's a matter for you ultimately.
Okay. That's helpful. Is there anybody else who wants to comment on landscape and visual matters? No, I don't see anybody at this point. So moving on to ornithology. Obviously, depending on whether additional information. Sorry, Ms. Knowles, are you commenting on landscape and visual? Do you want to come in now, or? Ms. Knowles? Hi. You're on mute.
Can you hear me now?
I can, thank you.
Yes. I'm concerned that the landscape and visual is it's very much concentrated on Highland and Murray. It's also going to have a huge impact in Aberdeenshire as well. And there doesn't seem to be anything being looked at on the Aberdeenshire side. Or will we be invited to contribute at, say, the Keith at the Murray hearing?
So there's nothing to prevent Aberdeenshire issues being raised at the landscape and visual inquiry. I think the main focus was talked about Inverness and Murray because those are where the two councils have objected on those matters. Obviously, Aberdeenshire Council didn't object, so wouldn't have a witness on these matters. So I think it comes back down to whether you feel that that would be an effective way if you want to present evidence to us, or whether you feel that the community hearing sort of format would be preferable. So that's a matter for you.
Yeah.
Okay.
Thank you. Thank you.
And Mr. Lound?
Yeah, just on this one, and actually probably goes right the way across. Do you have access to an independent expert to verify what's being told to you? I think it quite heavily drives the visual impact as to what technology is available. I know I've challenged SSE and I work in the industry, and some of the answers that they've given have been very selective to suit their case. So we just need to make sure that what you as reporters are being told is actually the absolute truth, and not something that's potentially to suit the application. So I don't know how you guys would independently verify. It probably applies right the way across, but I think it's very pertinent to the visual aspects, because if there's different tower constructions available, etc., to reduce tower height, that type of thing.
Yeah, obviously, so we'll be looking at all the evidence that's been submitted, not just from the applicant, but from all the other parties, and that will include matters that have been raised by councils, community councils and individuals across all the representations. So if we feel that there are questions that we have over any of the evidence or inconsistencies, then those are things that we would be raising in questions to the applicant. So it's perhaps something that you've already raised in a representation. We'll obviously be looking at that as part of our assessment.
Yeah, it just you may need, obviously, I don't think you should be taking my word for it or their word for it. It's somebody independent to verify those statements would probably be required.
Okay, well, obviously we'll have a look at what's been submitted, and if we feel we need further evidence, we will seek that out. Okay, right, so moving on to ornithology. So depending on whether additional information is required, obviously we've discussed that a little bit earlier in the agenda, we're anticipating an inquiry session with Nature Scott and others focused on the effects on the Darnaway and Lethen Forest Special Protection Area. We expect that would be in person in Inverness. It was penciled in for the 20th of August, but we think that could be brought forward to the afternoon of Monday, the 17th of August. So that would be the first day of the inquiry, but yes, the afternoon to allow for logistics. So subject to the views of Nature Scott in particular on that. And based on the evidence before us, we don't anticipate the need for further procedures on ornithological or ecological matters, but there may be some written questions that we ask. So could I ask Nature Scott, possibly RSPB and others for comments on those dates, format?
Thank you, ma'am. Just to clarify, is the suggestion that it's an inquiry session on only the afternoon of Monday the 17th?
That's correct, yeah.
Okay. In practical terms, I think an inquiry lasting only an afternoon, even potentially running into the evening, would be challenging. But we would have at least 2 expert witnesses, possibly 3, depending on whether RFPB intend leading a witness. And in my experience, 2 witnesses for a full day on a topic such as this would be a stretch. If it was 3 witnesses for part of a day, I just don't think that would be possible.
Okay. Well, that's useful. That's useful.
But that's really just from a timing perspective. Nature Scott's view is that a hearing session would be more appropriate irrespective of timing issues, for given the nature of the issues between the parties. And TPA Guidance Note 8 provides useful indicators as to where an inquiry session or a hearing session would be most appropriate. In this case, the difference between at least Nature Scott and the applicant is primarily an issue of issues of professional opinion, and that some of the indicators in the guidance note suggest that a hearing session would be appropriate where the difference is opinion as opposed to factual issues.
Okay, that's useful.
Just one final point. We do have experience of what are sometimes referred to as hybrid hearing sessions, where allowance is given to the parties to ask questions of the other parties through the reporter. And Nature Scott would be happy with a hearing session using allowing questions to the maximum possible extent. And I think coming back to the timing, a hearing session could fit within an afternoon session, potentially running into early evening. Thank you.
Okay, that's extremely helpful. Yeah, I think without understanding how many witnesses you were thinking about, perhaps we were being over optimistic, but we're certainly attracted to the idea of a hearing session if we feel that that's going to be more practical. RSPB, Esme, do you have some comments?
Yeah, we were also of the view that it could be dealt with by a hearing as well. And obviously that's depending on the information that might be submitted by the applicant, and we're aware that there might be opportunities for further written submissions if there are further submissions by the applicant and ongoing discussions. But yeah, we certainly thought from the information we've got just now that a hearing would be suitable for this.
Right, that's helpful. And in principle, you're okay with the 17th of August?
Yes.
Yeah, right, okay, that's good to know. And obviously we have got a little bit of flexibility, if we needed more time. Obviously we'll have a think about that, and once we see what the further written submissions throughout, then we'll be able to finalise that. Is there anybody else who would like to comment on the ornithology session?
Yeah.
Mr. Reid.
I would.
Oh, okay, sorry, Jean?
Yes, you're looking at areas in Moray for ornithology, but there seems to be no route for the small farmer or for the private individual to be heard. I've spoken to SSEN and things are ignored, everything's ignored. We've had no breeding bird count when we've requested one. The environmental impact study has not been done. They particularly avoided doing a raptor count over our farm. We're part of the bucket and corn bunting project. We've got feeding grounds that are endorsed by the RSPB, but we are being ignored and have no route other than this hearing. I feel that a lot of other people are also in the same position. You've got the people talking about visual impact in Aberdeenshire that's been overlooked by Aberdeenshire Council. Certainly through Aberdeenshire, we're not getting our voices heard. Things are wrong on the plans that have gone in. I've raised the subjects that they're wrong to SSEN before they went in, but they said they put them in anyway. So I think there is an issue with the system for the environment. It's not being protected.
Okay.
And I hear you talking about the community hearings and the hearings for visual impact. On ornithology, will we also get a voice? Will that be individual? Will it be at the community hearing?
So, I mean, that is to some extent up to you. So the community hearings are not limited to talking about any particular topic. They're not just about landscape and visual issues, for example. So if you wanted to come to a community hearing in your area to talk about your particular concerns, then that would be very, very acceptable. So we think that the main focus of the hearing on ornithology is around these specific impacts where there's a disagreement between the main parties. But it may be that you want to opt into the process going forward, and you can see what comes out of the further written submissions and then make a decision at that stage whether you want to be involved in the community hearing or in a separate ornithology discussion.
I would prefer a separate ornithological discussion if that were possible.
Okay, thank you.
Thank you.
Oh, Mr. Reid, you were going to speak.
Right, thank you, ma'am. In relation to the date, the 17th of August, causes some difficulty on our part, frankly, my availability, which it remains in the school holidays, and I also have reservations about whether in any form it could be accommodated in half a day. It seems to me there's both time in the second week with the reorganisation or the 20th of August, where we would be going to Inverness or Beauly in the evening if we don't necessarily think it'll be a full day, but it'll be more than an afternoon. Again, matters for your discretion, but I would ask that we consider avoiding the 17th of August, if that can be done, and it seems to me there is scope in the timetable for that.
So is that the only date? Sorry, can I just check? Is that the only date that is a problem within those 2 weeks for you?
Yes, yeah, the 17th causes a particular difficulty. Everything else can be accommodated. In relation to mode, it seems to me an inquiry is appropriate, at least on my understanding of the discussions. There remain factual issues which are not settled, and having regard to the approach, the indicative approach in relation to landscape and visual inquiry, that it seems to be consistent with the approach taken there. Again, it's a matter ultimately for discretion, and I'm not forcibly pushing in any particular direction, but I make the observation, my judgment is the appropriate mode is an inquiry, but it's ultimately, I appreciate your judgment, which counts, but I make that observation for what assistance it is in reaching a decision.
Okay, thank you. Obviously, my colleague and I will have a look at the timetable, and just there's a sort of balancing to be done, I think, between the timing and how much time we need for any particular session. So we'll certainly have a look at that and take into account what you've said. Okay, any other questions, Mr. Ferguson?
Yes, ma'am. Just on timing, the NatureScot team is available for every day in the 2-week window except Friday the 28th.
Right. That's very helpful to know. Thank you. Okay, let's move on to the next topic, which is conditions. So on conditions, the Energy Consents Unit has set out a set of draft model conditions. Now there's different versions of this, but the latest version that we have in draft is from February 2026. So we understand they're still in draft, but Energy Consent Unit is happy for us to use them as a starting point for the development of a set of conditions, and we'll include a link to those in the note of the meeting, and they'll be added to the foundation documents list. So on the basis of that, we do expect that there'll be a need for a hearing on the detailed scope and wording of a number of conditions, including on securing biodiversity enhancement and forestry replanting. Now, we're aware from Highlands communications last night that discussions on forestry and ecology matters are still ongoing with the applicant on mitigation, and we expect that these matters are primarily related to conditions, and that this could be addressed through the conditions hearing, but obviously we'll welcome comments on that, particularly from Highland in a moment. And the conditions hearing would also need to discuss a number of other matters that have been raised in representations and consultations, including on biosecurity, fish monitoring and mitigation, and other outstanding matters that are coming out, for example, on cultural heritage, and other things that may come out of the oral sessions or from the requests that we make in further written submissions. So there will be probably quite a lot of matters to cover there. Given the number of parties across, the whole geography that might wish to be involved in this, we had suggested holding this virtually at the end of week 1, but we now suggest moving this into week 2 on the afternoon of Wednesday the 26th, and that would still be virtual. So that's kind of our current thinking, obviously subject to some of the other tweaks that we may need to make. And we request that the applicant takes the lead on drafting the conditions based on those model conditions. And there's guidance in the draft model conditions on preparing a version that shows all the different comments that come forward from councils or other consultees. And although Aberdeenshire Council's not objecting, we do expect all 3 councils would want to be involved in the conditions hearing, and would welcome Aberdeenshire's comments on that today. And others are very much able to participate if they feel they've got a particular expertise, and alternatively, if parties want to observe the proceedings, then they'll be able to do that via the webcast. And we will certainly make sure that the initial draft set of conditions, once it comes forward, is made available on our website so that everyone can see the draft details. So if the applicant is content with that, we would request that draft set of conditions in the note of the meeting, so that can be submitted along with the deadline for probably the first set of further written submissions. So could I ask for views on the conditions hearing? Mr. McIntosh?
Yes, ma'am, Aberdeenshire Council are quite keen to be involved in the conditions, and we'll take into consideration those draft conditions which we've seen raised before in other similar inquiries.
Okay.
We would aim to work closely with the applicant and the other councils to agree as much as possible, with no strong views on whether it's held in place or virtually. I would leave that to the reporters to consider.
Okay,
Thank
but the
you.
date in principle is okay with you?
The date's fine, thank you. Yeah.
Okay, that's helpful. Ms Scott?
Yep, we're also happy to work on the conditions, obviously depending on how much agreement can be reached in advance. It may take longer than an afternoon.
Right.
And also in relation to other parties, no disrespect to members of the public, but planning conditions generally are the domain of planning officers or parties with qualifications in planning and legal aspects. So we would expect that to be the main parties would be the planning authorities and the applicant.
Okay. Mr Finlay?
Yes, thank you. I'm grateful for the change of date. That date would suit us. Virtual hearing would appear to be sensible given the number of parties involved. I echo the concern about whether it can be done in an afternoon. It might be a lengthy afternoon. Conditions do tend to sometimes take some time, particularly if matters such as forestry and other matters do turn out to be more of a conditions issue than a substantive issue, which they may well do. It may well be that a lot of Highland Council's objections resolve themselves into a dispute about conditions as opposed to a merits dispute. So subject to those points, agree with the proposal.
Okay, that's helpful. Thank you. Mr Ferguson, did you have another question, or was your hand still up from before?
No, it's a fresh point.
Thank you.
There has been some discussion about a shadow assessment, and depending on how that goes, it's possible that there could be specific discussions on conditions to secure, or indeed planning obligations to secure delivery of any compensation. And sometimes specialist conditions such as this are discussed in the specialist topic. So I just wanted to clarify whether there was any scope for ornithology specific conditions being discussed in the ornithology session rather than the main body of the condition session. I should also have clarified when I spoke before whether policy was likely to be discussed in the context of the ornithology session.
So on the matter of conditions, I think given the timing, if ornithology is up first, I think that would be sensible. However, we obviously haven't got the councils indicating that they want to take part in that session. So that would be my only hesitation about whether there's things that the councils would want to comment on. But it may be that they're happy to take your lead on that. So if possible, if we can resolve them within the ornithology session, that would be fine with us. On the policy front, we're not anticipating the need for a separate policy session. So I think if there were any particular policy issues, I think we would be happy to cover that within the session as long as we have, the time available. It depends how much of an issue you expect that to be, but if we can accommodate it within that hearing, then that would make sense.
Thank you. It was primarily from a timing perspective I was asking the question, because if there was scope for the session to expand into policy, then again that might be a difficulty in achieving completion of the session in one day.
Yeah.
Thank
okay.
you.
Well, I think we will need to go away and think about the timing of that anyway. So we'll take that on board in relation to that point.
Thank you.
Okay. Are there any other comments on conditions, Mr. Reid?
Thank you, ma'am. Content with a virtual hearing session. Listening to what Mr. Finlay's had to say, I wonder if the prudent course is not to have a day that we don't need rather than a half day that needs to run on excessively. I can see some force in that. In relation to taking the lead in drafting conditions, there's absolutely no difficulty in that, but we wonder in respect of that whether a period of 4 weeks from the issuing of the note might be helpful, having regard to the other work that we're also undertaking to try and share as expeditiously as we can. Again, all a matter for your discretion and judgment, but it seemed to me that might be a helpful period of time for us to have.
Yeah, I think we were already thinking about a 4-week period for the initial round of further written submissions. Obviously, we've got this slightly parallel issue of the additional information, so we'll have to look at whether we need a shorter deadline on that. But the main body of further written subs, we were probably looking at 28 days anyway, so that would tie in with that.
That's a helpful indication, I'm obliged.
Yeah. Okay, any other comments? Okay, so we'll move on to further written submissions. So we've indicated in the appendix the main sort of topics that we definitely expect there to be further written submissions on, but there may well be more detailed site-specific questions as well as we go further into the evidence as we go along. So this further written submissions means that we will ask specific questions on these topics to specific parties requiring a response within a set timescale. So just to touch on these quickly, cultural heritage, obviously we've mentioned that already. The position on Beaufort Castle seems to be clearer now, but we will have just a few questions around Mains of Daviot. And we're reasonably confident that we don't need any other information on cultural heritage matters. Traffic and transport we have mentioned also earlier on, and obviously that's particularly in relation to Highland Council's concerns. And subject to further discussions on those with you, we may consider it necessary to hold a hearing to get more clarity on that, but we're hopeful we can do that through written submissions. And it's not to say that transport concerns haven't been raised in relation to the other local authority areas, but we do feel that there's a few questions we want to clarify around the areas of disagreement with that Highland Council have raised. Agricultural operations, so one of Mr. Thornton Kermsley, I think it was earlier on in the meeting, raised the matter of agricultural operations. So we certainly have got some questions that flow from concerns and representations over the effects on farm machinery and the effects on farm operations more generally in and around the proposal. And we're aware that that was scoped out, but we will want to ask a few specific questions on that to the applicant. Radio communications infrastructure, we understand that there's still an outstanding objection from the joint radio company. So it may be that discussions are ongoing and that's been resolved, but if not, we want to ask some questions on that. Excuse me a second.
Sorry to interrupt, Mum. I can say just at that point there are ongoing discussions in relation to the radio communications infrastructure, and hopeful that might help resolve matters, but that'll be updated in due course.
Okay, thank you. And on the matter of need, obviously, we also want to provide an opportunity for any updated positions on the matter of need, and that may include reference to recent ministerial decisions on other parts of the ASTI programme, but it's certainly not limited to that. And obviously, we're aware, Mr. Kelly, that you've made representations on this matter, and again earlier to DP earlier this week. So our current thinking is that an oral session would not be required, but we are very happy to receive any further evidence in writing. We're not looking for parties to reiterate any points that are already made, only to provide any updates if you think that there are any. So we would welcome views on that approach. So as I say, there will be other questions around Rayshaw farms and the implications of that, and there will be probably some other detailed questions, a limited number of sort of site-specific questions that come out of individual representations. But that's the main topic. So beyond that, I would reiterate that where there's no further procedure listed for a topic, that doesn't mean that those matters are not of importance. It's simply that we think that we have enough information to write our report to ministers. So could I take some comments on the matters for further written submissions? Mr. Finlay?
Yes, I'm very much in general agreement with your approach. Just a couple of points to raise. One is I'm instructed that the council's conservation officer has some concerns over the Culloden conservation area. That is a potential concern. I'm not sure how whether that is going to be that's still under consideration, but that's a potential concern under built and cultural heritage, which could be dealt with by written submission. The other point I wish to raise is that a number of our other objections, particularly residential amenity, which is not one that's been raised so far, is likely to be a conditions issue. But we're assuming that the conditions certainly be quite broad, in which case we won't need to make further written submissions on issues such as that. And you've already touched on woodland and other matters where there are ongoing discussions. So in general agreement, just that one point, I believe, to add.
Okay. Actually, Mr. Finlay, your point there has reminded me that there were comments from the council about a number of landscape matters that I think we're still waiting potentially for a response from the applicant on. So I don't know whether Mr. Reid can come back to me on that in a minute, or do you have anything to say on that, Mr. Finlay?
I don't have anything further to say on that. I think on landscape and visual impact matters, we may be waiting for, there's still discussions, but we are anticipating a hearing or inquiry at the moment, obviously subject to our point that the council hasn't reached a formal position as to whether it will object or not.
Okay, so perhaps Mr. Reid, in a second, if you could respond, excuse me, on the matter of whether, are you going to respond to those issues that the council's raised specifically? I think there were 3 issues in relation to landscape and visual. Are you planning to respond to that before the council gives its final view in June or not? But you can come back to me on a second. I'll go to Mr. Kelly first.
Thank you. Thank you, ma'am. On the matter of need, we were looking for written exchanges fairly early on. To explain, I have to jump further north to the Spittal to Beauly section of the line of the project. Since that was first announced, we've been asking SSEN for the mathematical basis of their need case in terms of generation capacity and transmission capacity, both now and in the future, based on named wind farms and named transmission projects. We have never had that detailed information provided. All we have had is generalised statements in relation to ASTI or national planning policy. So in relation to need, in the context of this being a project effectively spending public bill payers, electricity bill payers' money, we are looking for the mathematics of the need case, and then we will respond to that. And we're happy to do that fairly early on. Thank you.
Okay, thank you. Anybody else? Mr. Reid, are you able to respond?
Thank you, ma'am. In relation to the issues with Highland Council, discussions are ongoing, and obviously we would hope that if they have reached a conclusion one way or the other before the council's taking a final decision. But I'm told that the discussions are ongoing. In relation to need, quite content with the position that you outlined and it being dealt with at that stage, as opposed to accelerating it to a period when everyone's preparing for the inquiry. I also observe, of course, the context in which we're looking at this is as a matter of energy policy, the requirement this line being set, and I simply observe that matter of energy policy is reserved and so not within executive competence of the ministers. But there's no issue to which I say requires need to be brought forward and accelerated out with what you had already anticipated and proposed.
Okay, thank you. Okay, any other comments on the further written submissions approach? Let's see any. Okay, so we'll turn to item 5 then. It's just to give a few comments on some of the other evidence that we may need. First of all, as part of the evidence gathering, it may be useful to provide statements of agreement between the applicant and the other parties, setting out matters where there is agreement, helping us to focus our reporting on the areas of disagreement. So obviously that's something for the main parties to consider. Is there any comments today on areas where you think a statement of agreement would be useful or is currently in preparation? And if those statements are going to be prepared, I think we'd find that useful to receive them at the same time as we receive the list of foundation documents. And I'll discuss that a little bit more in a moment. And that timing would allow those responding to requests for further written submissions or submitting hearing inquiry statements to be as focused as possible. So we'd welcome some comments on that. Mr. Reid?
There's not such a document under current discussion, but as would be my normal practice in any sort of hearing, if there's scope for agreement, absolutely happy to discuss that, and absolutely understand that being brought to your attention at the sort of time that has been indicated, but it will depend on the outcome of the ongoing discussions. But if there's scope for agreement, that will be recorded in an appropriate form and made available.
Okay, thank you. So perhaps no need to hear from anybody else unless anybody at the council? No, happy. That's fine. So as I've also mentioned, we might need additional site inspections. We expect at this stage to do that unaccompanied. We've not identified so far the need for any accompanied site visits, but if we do, that would only be for the purposes of access to a property. It's not about hearing further evidence out on site. So it's just so you're aware of that, and we will we'll see whether we need that as we go along. And finally, we will request closing submissions in writing 14 days after the close of the oral procedures. These will provide a summary of the main party's case on the evidence heard at any hearing or inquiry sessions, with the exception of the community hearings, and they shouldn't contain any new evidence. So we have a template, and that would be issued with any necessary explanation after the oral sessions end. It asks for a succinct summary of case suitable for inclusion in the reporter's report to Scottish ministers. And the order for making closing submissions will be councils and other parties within those first 14 days, and then the applicant will submit 14 days after that. So each submission would be sent to those parties who are preparing closing statements, and they'll be posted on the DPA website. And we will confirm the exact dates for those submissions in the note of the meeting. So any questions on any of that? Everyone content? Great. So I will pass back to Mr. Beauly now for item 6.
Thank you. Item 6, participation in further procedures. A bit of a health warning, I suppose, that for anyone who's not very familiar with the more formal procedures that we've been talking about, such as inquiries or hearing sessions, there is an administrative burden involved in getting involved in those. You need to put in written statements well in advance, etc. There are very strict deadlines that we will enforce. And we appreciate if you don't do it for a living, which many of you don't, that can be quite onerous. But we do need, in order that the process is transparent and fair, for those very formal processes, we do need to stick to a rigid timetable. You must put evidence in advance. You mustn't spring surprises on the day, etc. So I don't in any way want to put anyone off participating in a formal hearing or inquiry session, but just to bear in mind, people who've given us feedback say, well, it is actually quite a burden to keep up with those who do it for a living, and we understand that. And that's part of the reason why we have these community hearing sessions, where we not only is the event itself less formal, but we are less strict on how far in advance you need to give us an indication of what you're going to say on the night. We do still insist that you give us prior warning, again, in the interest of transparency and fairness, but it's a lot less onerous, if you like, for somebody doing this on top of their day job to get involved in a community hearing session. As we said earlier, if there are a lot of you wanting to make the same point, it's quite often better for you, whether it's in a community hearing session or in a more formal session, to nominate one person to make that point rather than you all say the same point. So if you have a range of points, you could divide them up and individuals could focus on certain, particular areas of passion for them, and others could feed into them. So effectively, they would speak on everyone's behalf on that particular topic. Next week, as I think we've said, we'll issue a note of this meeting. That is your formal invitation to get involved in any further procedure. So you need to make sure you respond within 14 days of that going out, indicating which of the procedures that we set out in the note you want to get involved with. So far you've opted into the process up to now. There'll be a second stage of opting in to one or more of the procedures that will be going forward from now. You're obviously not obliged to opt in. If you decide, actually, I've had enough, I just want to watch it, then obviously you'll be able to keep fully informed with the progress of the case on our website. And as we've said, our aim is to webcast all of the sessions to our YouTube channel, so you'll be able to watch it online. Or, of course, where sessions are in person, you're very welcome to come and watch from the audience if you decide you don't want to actually participate. But as again, I don't want to put anyone off participating. If you're up for it, we'd very much welcome your attendance and engagement. So item 7 on the agenda was just a little bit on document management, which again can be a little bit daunting for people who are not familiar with it. We have, or we will set out in this note of the meeting, deadlines by which various documents need to be submitted. So if you're participating in a formal inquiry or hearing session, dates are calculated back from the date that session will happen, and those are the strict deadlines for when you need to put in various bits of evidence. So all of that will be explained in the note of this meeting. And again, where we'll be seeking further in submissions, it'll be clear in the note of this meeting when we want to have those by. We will either issue requests for further information with the note of this meeting that we issue next week, or very shortly thereafter. So we want to get it up and running as quickly as possible, because summer will soon be here and gone. So we need to make sure that everyone's got the chance to get working on those written submissions as soon as possible. In terms of document management, we've got a reported guidance note 29, which is a revised procedure. It's probably a year or so old now. The idea, although it sounds quite complicated, the idea is actually to simplify the process. What happens is the case officer will start, and I think they have started, an electronic or a list of core documents that reside within our core documents library. Each document having a hyperlink, so when you look at the list, you can just click on it and go straight to that document. So that list will be sent to the applicant, who will expand upon it with any other documents that reside again within our online library, things like policies and guidance documents, etc. And then other parties can add to that list. These are called foundation documents. So those are the sort of core documents that are stored by us all the time in our library. So anything there that you think you want to refer to if you're participating in procedure later on, you need to add that document to the list, and the applicant will take responsibility for providing a hyperlink to our library, so that everyone ends up with a foundation document list which they can have in front of them at the inquiry or hearing session, and then simply click on that, and we're all looking at the same copy of the drawing or the document, whatever it is, with the same page numbering, etc. It avoids duplication. Multiple copies of the same document can be very confusing. So in addition to those foundation documents, there are also what we call supporting documents. So those are case-specific pieces of evidence, articles, anything else that you think supports your case and which you definitely will refer to on the day. So if there's something that you want to specifically point out that isn't in our document library, then you would provide it to us by a deadline, which will again be set out in the note of this meeting. And you, in advance of that, you'll tell us that it's coming, if you like. So you'll say, I'm going to be referring to document X. And again, the hyperlink to where that is stored, once it's submitted to us, will be added to the foundation document list. So again, on the day, everyone can simply click on the link, and everyone's looking at the same piece of paper or virtual paper. So again, the idea is avoid duplication. Please do only submit documents you really intend to refer to, because if something comes in, we have to read it. So and to be honest, since we revised the procedure, it seems to be working quite well, that people are no longer submitting everything in the kitchen sink for us then to read. They are actually thinking before they just throw lots of documents at us. And if you only refer to part of a document, by all means, just submit that part. If you don't want to rely on anything else, then don't send it to us. So we only have to read the excerpt that you're interested in talking about. So that's document management. As I say, look at the guidance note on that report as guidance note 29, which we'll put a link to in the note of this meeting. And if you have any queries, the case officer's very helpful. They can advise you on how to deal with that process. As I think we said before, hearing sessions, inquiry statements, etc., all need to come in by certain fixed deadlines so that they're in advance. There are no surprises on the day. The same for community hearing sessions, albeit the deadline may be a bit later. It's still a deadline that we enforce. In terms of how you submit the documents, in the past, we'd all be emailing each other documents, and that can lead to confusion or people not receiving things at the time they should do. So what we have in recent years been doing is using a system called Objective Connect, which is an online site where you can upload your documents. So if you opt into further procedure and you know you're going to want to be putting in documents to refer to later, you'll be given a password to the site, and on the relevant deadline date, you'll be required, or before, to upload the documents to that site. And other parties, again, by the deadline, will have done it similarly. So there's no need for exchanging emails or confusion. There'll just be one place where everyone uploads their documents. It also means you can upload large file sizes and they won't bounce back because they're too big to send by email. Again, we'll send you some details of that in the note of this meeting, and there'll be a link to some relevant guidance on that as well. So, the message really is we hope it isn't too daunting for members of the public to get involved. We're trying to make it as simple as possible, but we're quite strict on the deadlines to keep things moving along, to avoid absolute chaos in the week prior to inquiry, which perhaps used to happen on occasion when documents were late and everyone's running around panicking. So we are now quite strict on adhering to deadlines, but subject to that caveat, we hope the system now is a bit easier than it might once have been. So does anyone have any queries on the sort of procedure that before we go on to the next item, which is about contact information? Is everyone clear? Okay, I'll hand back to Ms. Leven.
Okay, thank you. So item 8 was just to give you a little bit of information about contacting us. Firstly, rather than having one case officer, we've actually got several case officers who are supporting the administration of the inquiry. And so we've set up a dedicated email address, which is being monitored every day by the case management team. So they will liaise with us as necessary, make sure that we've got all the documents and that documents are circulated or made available on the DPA website as required. So we'll provide full contact details in the note of the meeting, and just to say that you can still call the office and speak to staff directly if that's more helpful. Item 9 was just to ask if there was any other business that people haven't been able to raise already. Mr. Reid?
Thank you, ma'am. Just 2 points that arose that might be helpful for me to touch on at the moment. There was mention of a moving of a pylon in Peterhead. I'm told that's the diversion of an existing line for the Netherton substation project, so not part of the Beauly to Peterhead project. Thought it might be helpful to mention that at this stage. And I think you, ma'am, asked about drawings, in particular what was Appendix 4 to the position statement. That is figure 3.2, which is volume 3 of the EIAR, and of assistance relevant to that as well are probably figures 3.1 and 3.3. That's information I've been passed in the course of the hearing. I hope that's of assistance at this stage. Otherwise, beyond being grateful for the indication of where there are areas of concern and the further procedure, and having had the opportunity to hear what those that have taken time to join today have had to say, which is also instructive and helpful for the applicant. I've got nothing further to add. Thank you.
Thank you, Mr. Reid. Any other questions at this stage? Any other additional business? Okay. So just on to the final item then, the note of the meeting. As we've said, we'll issue that note within 7 days, and that'll set out how we're going to proceed, and that'll be a key reference point for all of you as we move forward. We won't seek comments on that note. It will be issued on the basis that it sets out our conclusions on how the inquiry will be conducted, and it's likely to, we're hoping it'll set out the specific matters, or shortly after we'll set out the specific matters on which we require further written submissions. All of the dates for the proceedings will flow from the date of that meeting note. And importantly, as Mr. Beauly said, parties will be given 14 days to confirm whether you wish to take part in a particular procedure. So you must respond within that timescale if you intend to actively participate going forward. And if not, we will still have full regard to what you've said in your written submissions. And subject to webcasting, you'll be able to view proceedings on our YouTube channel. So that's all that we have to say today. We thank you very much for your time today and for your patience with the IT issues in the middle of the meeting. I now formally close the meeting. Thank you.
Thank you.
Thank you.